So you have to substitute somebody in his place. I'll do it. The accused number one is accused is fired. The complainant shall take steps to substitute the complaint accused.
Ninth of April. The 19 disposed, still number 20.
We'll take it afterwards.
Over. Number 21.
For the respondent in this case, my lord, I appear for the appeal to start. The commercial appeal is filed challenging the order of the Blood Commercial Code in the interlocutory application filed along with the suit, the trademark infringement and passing of suit, wherein the Commercial Code had allowed restrained the appellant herein from using the mark Celtic for the product salt, which falls under class 30 of the nice classification, my lord. Celtic is derived from, so defendant's products, appellant here's products were available. Appellant here's products were available in the market named Namo Organic Celtic Salt, which was available for sale primarily in Amazon, Flipkart, and also in the appellant's website called namoorganics.com. The respondent herein was selling a product name under their registered trademark Sambike Foods for Sambike Celtic Salt, where they have claimed a user date from 2023. Celtic is a generic term. Despite being aware of that and they being themselves in the market, they approached the current commercial code and filed the interlocutory application seeking for an interim injunction. The learned, we had entered in the appearance force getting the summons. We had said that Celtic salt is generic term. The term is arrived from the Celtic Sea, which is in the northwestern part of France. The salt which is derived from the Celtic Sea is not a Celtic salt. It's identified that trigger products, my lord. Hence, we told it's barred under Section 9 of Trademark Registration. Trademark registration cannot be granted. In this matter, they claim to have filed applications. Their applications were not allowed, were objected or in the category of formalities check pass at the time of the suit. Right now, what I understand from the state is the three applications what they filed for Celtic, Celgris, etc. under class 32 have been objected and one has been abandoned. So accordingly, when I got the interim order against me, I approached this honorable court. This honorable was pleased to grant a stay of the order. Hence, my lord, my contention is first primarily, if you see, the word Celtic itself is a distinctive and descriptive word. The Celtic is used to describe
your oppositions are pending.
The trademark registry is objective. There is a registration of
the oppositions are pending before the registry.
Yes, my lord.
We filed an application for registration of trademark.
So that is free.
It's pending, my lord.
So let that be decided first. You can't injunct them.
It's a matter of trial, my lord. So in the entire country, my lord, I'm the first user of the Celtic.
Lordship, Celtic has been there. It's been used for past 100 years. I have in my commercial appeal. I have put a series of other products where Celtic salt has been used. And also, my lord, just to bring your attention of your lordship, what I understand
on record, my lord.
Understood from the trademark registry is their mark Celtic salt Celgris word mark under class 30 is objective. Celtic salt self-fin is also objective. For the registration for the application for the mark Celtic under class 30, they are abandoned. They are abandoning the mark itself proves that they are We are well aware that the lordship may permit us to bring this on record. They abandoning the mark itself evidences that they are well aware this is a generic term and they cannot apply seek for trademark registration here. If I was using their mark Sambike, I can understand I can be claimed as infringement. I'm not using the mark Sambike. They also admit that I'm not using the mark Sambike. In fact, my products are available in the market as Namo Organics. And also, if your lordship will well know, when you list a product in Amazon, Flipkart, and all, there will be a category under which we can list your product. So Celtic is one category. So if I'm not able to use the mark Celtic or click on that category, then my product won't be sold.
Only on 3 submissions, my lord, with regard to that. But my lord, the Celtic, the term in India, my lord, we are the first user of the Celtic name. I mean, we also filed an application for registration of the trademark license. Then, my lord, the Celtic basically means sea, which is not a generic term at all, which is a patently wrong. The submissions made by the applicant is totally wrong. The learned trial judge has passed an order in favor of me, where the Celtic and Sampike are the not general term, which the plaintiff had filed an application for registration of trademark, which is still pending, my lord. So the matter has to be yet to be decided at the trial, my lord. So, my lord, the interim order is operating against me.
If there was a registered trademark, I understand they can ask sake of infringement. They don't have a registered trademark. How does the question of infringement arise?
They are not even faced any records, my lord. With regard to Celtic is not a general term.
Lordship, may kindly see page number 25 of my appeal paper book, my lord. It would be like someone claiming registration for Himalayan salt or apple cider vinegar tomorrow, my lord.
So we'll have to hear this. We'll put it for final hearing. What has happened before the commercial court?
Yes, my lord.
What happened in the commercial court?
Commercial court,
Trial has commenced?
No,
Not
my
yet, my lord. It has to be
No, not it,
commenced.
my lord. After the IA has been disposed of, since there was order, the matter is not. To be honest.
This for final hearing.
15th of June.
Order may continue.
There are models.
Number 22.
Suit for recovery of money was dismissed. Last date of hearing, the matter was heard. I filed 2 applications seeking production of additional evidence, my lords. I filed another application which was directed to be filed in the registry. Short question, my lords, the question of hand loan, which I've advanced to the defendant from 2018 to 21. The name of the defendant and his business enterprise. 2 issues were framed by the trial court, my lords.
Give them one more chance. Let them come. We'll give them one more opportunity. Nobody is present here.
No, my lords, they have been served in under last 2 days. No advocate is on record.
Let's see the order passed by the commercial court. See, the question is, you've given your payments to Modi, is to the firm.
Initial payments were made to the defendant himself, thereafter to the firm of the defendant. His contention in the written statement is that he's taken over the business of Modi Sons post 2021. That is his case. He does not deny that he is nowhere related to Modi Sons. Lords, what I have produced now a document, the GST registration certificate, which is my appeal memo, which clearly goes to show that the defendant's name is registered in the GST so far as Modi Sons is concerned since 2017 itself, to show that he was in fact the proprietor of Modi Sons. My lord, it's at page 41, my lords, of my appeal memo, document number 1.
Remanded. All right, we'll remand it back. We'll set aside and remand it.
And the question of question of limitation also is there, which has been answered in the negative against me.
Where is your limitation issue?
My lords, may kindly see the reasons. Page 87, my lords. Issue number 3 and 4 relating to suit whether it's barred by limitation. Page number 87 of the paper book.
Page number?
Page number 87 of the paper book, my lord. 10th line, my lords. Further, as rightly pointed out by the defendant, relying the contents of documents relied by the plaintiff himself, the transaction dated 15/1/2021, 16/1/2021, and 25/1/2021 are pertaining to the year 2021, and present suit is filed on 31/7/2024 after lapse of 3 years. Therefore, suit is hopelessly barred by law of limitation. Argument seems to be reasonable.
This you're claiming the benefit of that?
Yes, yes.
So moto.
Yes.
All right.
That's okay.
You have the copy of that order?
Yes.
So motor order 3. We'll give that.
The second judgment, my lords, page number 6. Judgment portion, in
Yes.
page number 8, para 5 on this. That's the direction that is passed. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated so and so and so, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial qualities. Literally, my lord, the financial transaction in the year 2021, when the Supreme Court order was in operation, my lord.
No, which one are you referring to now?
My lord?
Limitation would have expired during this period. This limitation doesn't expire in this. This is what it is. There's one day. No, much more.
urgent,
One
Silamba.
more submission. One more IA was filed for production of documents. Twice.
We'll allow these applications.
Number 24.
I pray leave to appear for the appellant's counsel.
Yes.
And is a case where a decree was obtained and in commercial OS 422 of
May be
24.
permitted to file counter to the application for condemnation of delay. May not
Yes.
counter to the application for condemnation of delay.
Yes.
Copies.
Yes.
There was a previous order passed in a miscellaneous petition, Mirad, in the same court, in the commercial court. That was by which the petition was rejected. On that, Mirad, we had preferred a commercial appeal, confining ourselves to the petition under Order 9, Rule 13, as mentioned by my lord in para number 2. They have confined the present appeal challenging the impugned order whereby the appellant's application for setting aside judgment decree was rejected under Order 9, Rule 13. Now, that apart, my lord, I am pointing out to this honorable court that, my lord, it's a matter of record that, my lord, the defendant's case has not been put forward before the trial court at all. Purely on technical grounds, they have been kept away. Admittedly, only from the stage when the property is attached. Now it is brought for sale. I believe it is scheduled to be sold in public auction on the 5th, and court sale is on 7th. The short manner in which the case was filed, summons was not served upon the defendants. One signature is found from the certified copies.
That is over, that we have already decided.
All I'm requesting is Sangram Singh's case. I'm relying upon that
But to show
judgment.
what is on the
Right.
record, what is it that the
All through I have been kept in the
judges
dark.
gone?
I have no option. The civil procedure code, my lord, it is an opportunity to contest, my lord. They cannot trip me away from the court and say that we have obtained decree. Therefore, the whole thing is a fraud according to the defendants. The challenge is so far as the transaction itself is concerned on merits. We have never had any transaction regarding 116, 120 kgs of silver at all. The proof is pertaining to a separate loan for 40 lakhs for which we have no grouse. We admit that fact.
Let's see what the judgment.
Judgment believes without any documentary evidence, the court believes the fact that there is a transaction, and my lord, kindly see the judgment. Paper book on judgment. 98 in the paper books. Suit for recovery of 1 crore 12 lakhs 50,000. Case of the plaintiff in brief is so and so. And kindly come to the documents. I'll read the whole thing. It's a short judgment. The plaintiffs were running jewelry shop in name of Srinath Jewelry Mart at Raja Market Avenue Road. On account of health issues, the plaintiffs closed the said business, having stock of silver worth 120 kgs. Defendants, also being engaged in jewelry business in the month of March 2020, approached the plaintiffs requesting them to give 120 kgs of silver, which they intend to use the same in their business, and agreed to pay a sum of 66,000 per month as interest. Allah also agreed to return 120 kgs of silver after 1 year. Believing the words of the defendant, the plaintiffs gave 120 kgs of silver to the defendants on 3/3/2020. The defendants gave 7 checks worth 56 lakhs and also executed a letter to the effect of 3/3/2020, mentioning the details of the checks and amount in each check. In addition to the said transaction, the defendants also availed hand loan of 40 lakhs from the plaintiff by mortgaging title deeds of their property bearing number 2, municipal number so and so, situated in ground floor at Chaudeshwari Temple Street, Chikpete, Bengaluru, and registered the same in the office of the sub-registrar, Gandhinagar. The plaintiffs further submitted that the defendants have paid interest at 66,000 per month till 29/5/2021. Thereafter, they have stopped paying interest and also did not return 120 kgs of silver. It is submitted that in spite of repeated demands, the defendant kept postponing the return of 120 kgs of silver, also failed to pay the cost of silver. During the first week of August 2023, the defendants requested the plaintiffs to present the checks gave by them towards payment of cost of 120 kgs of silver. Accordingly, the plaintiffs presented the following checks for encashment. All the checks, my lord, is 9 lakhs with 2/8/2023 is the date. simultaneously filled up with the same date throughout, and all checks were presented as per page 102 for encashment at State Bank of India, Puttanalli branch on 2823 and the Gandhinagar branch and on 5823. All checks were dishonored with Shara, payment stopped by drawer, which was intimated as per memo. Thereafter, plaintiffs informed the defendants about dishonor of checks, but defendants have failed to make payment. Finally, 22/8/2023, plaintiff issued legal notice calling upon so and so. Thereafter, plaintiffs filed an application for pre-institution mediation, commercial court, district legal services. Notice sent through under mediation was served on the defendants, but the defendants failed to appear and pre-mediation institution proceedings came to be closed. Concerned authority has issued non-starter report, etc. Kindly come to the next page, reasons, my lord. Plaintiff 1, in support of plaint governments, filed his affidavit by evidence, reiterating made in the plaint. He's also got marked 15 documents, exhibits P1 to P50. P1 is a letter issued by the plaintiff, executed by the defense in favor of plaintiff with respect to taking off 120 kgs of.
Let's see the evidence on that. What is the evidence on record on lending 120
Please, my lord.
kgs of silver?
Exhibit P1 is what they say. Exhibit P1 actually.
ಇದು ತಾನೆ
P1 and P2. P1. My lord, exhibit P1 is a letter by which the plaintiff claims that it is returned to him. You are aware that during the course of business, you have supplied 120 grams of silver on several occasions. With an understanding, we have agreed to return silver metal within 1 year and also paid 66,000 towards interest per month in view of the supply made by you. We have also arrived at an understanding that the interest and profit silver will be reduced proportionately as and when delivered the silver and interest on completion of the return of said silver. You are required to discharge the DTD subject to payment of 40 lakhs. So that's what is mentioned. Nowhere it is mentioned as far as the claim and receipt of those one-time payment is concerned. That is exhibit P1 marked in OS, commercial OS 422 of 24. My responsible submission firstly is that I had no occasion to file written statement. This is a background of the case is important, my lord. I have to state it orally because I have not been able to put it in writing before the trial court. I have been prevented from appearing and contesting the matter. There is a suit for partition and separate possession amongst my brothers and myself. We are all litigating towards the property which my father has left. Unfortunately, the plaintiff Lingaya Shetty is related to my elder brother. He has been set up by my elder brother to file this false suit and disposes me from the only business that I am doing in the shop. I have borrowed 40 lakhs from him is a fact. I have to repay it is also a fact. If I was given opportunity to contest the matter on merits or settle the matter, I would have settled. The first instance, PIM also, I did not receive any summons. My son's signature has been forged. I found from the certified copy today also, I verified the signature of my son has been forged in the registered post notice sent from the commercial court. On that basis, the commercial court has made an order noting on the order sheet that the registered post is served. But my lord, on the same day, the noting says that copies are not issued to the assessed to different through court, not issued for want of copies. My lord, kindly see the notings, my lord, 25/4/2024 noting, my lord. It is in the certified copy which I have got. I request this honorable court to kindly have a look at the notice. I can find the copies itself with memo, my lord.
No, this is not a ground that you took in the earlier case that your signatures are for.
Unfortunately, he was not being represented properly is my humble submission.
No. You were proceeded.
I am taking these grounds, my lord. I can at the law. Even I have no other way, my lord. I have no other way.
You have no other.
That is what I am saying.
You had a suit comes to be filed.
My lord,
You don't appear.
I didn't receive summons. my
Summons
lord.
were issued. Then you filed an ex parte, you filed an application saying that after some time to say that you should be, your ex parte decree should go. That is rejected. There you don't say your signatures are forged.
That was the problem, my lord. It was not represented
When you
properly.
file an appeal,
This is a mistake of the council who represented.
Even in
He
the
did
grounds
not
of
take
appeal also
proper
such a
steps.
ground is
Sir,
not
let
taken.
me complete.
Even in the grounds of appeal also such a ground is not taken.
here it is taken.
Here they have not, the ground is,
Here
there
is
is no
taken.
ground that
Kindly,
there is a
kind
forgery,
challenge
etc.
of the decree and order sheet.
There is no ground that there is a forgery of his signatures have been made as, with regard to service of summons. That is
At
not the
any
ground.
stage, fraud can be pointed out, my lord. I have verified, my lord. That is a fact, my lord. Sangram Singh's case is on right.
Sangram Singh's
May I
case
read,
doesn't-
may I
doesn't
read
say
that
that-
judgment?
You can have a, you can look at it again and now come back, have a fresh thought, so you'll find a fraud.
My lord, Sangram Singh's case would apply, my lord, is my humble submission.
That we will deal with.
All I'm requesting is, my lord, all I'm requesting is an opportunity, my lord, to contest the suit on its
And
merits.
that's not the scope. You tell us, what is your,
My request is 40 lakhs, my lord, is what I'm due. I would pay it in installments and close this matter. I'm not due that 120 kgs of silver. Why will anybody, without law, he would have lodged a police complaint in the natural course of business or circumstance if I had defaulted. He has not done so, my lord.
what about this T1? This is also forged.
Forged.
This 23 page.
Yes, my lord. Kindly see the
It is
signatures.
his letter, my lord.
That's what they say. That's what they say. The court has believed because I am ex parte. No contest. Very cleverly they avoid the postman and see that the signatures are forged. It is possible that has been done.
No, not postman. We are talking about P1.
Including that document, my lord.
That is also forged.
Yes, my lord. This is clearly concocted. They might have obtained blank signatures while giving that 40 lakhs and used it to subsequently now added. It is a fact that they have added that.
Are the signatures forged or are they blank?
My lord, I would say that the signatures.
No, you can't say anything. You have to say it in your what have you said in your,
I have to put it in writing, my lord, and say.
so what? Where have you said this?
No, that is not said in the.
My lord, I am placing additional grounds, my lord, if permitted now. They have been very badly let down, is my humble submission, my lord. They have been kept in the dark and the whole family is on the streets. They don't have proper facilities to live. Now, ex parte sale of property is slated on the 5th, my lord. Spot sale and court sale is on the 7th.
Pre-mediation notice is also served. Notice, legal notice is also served. Then there are court notices also served.
Why didn't you? No, that he admits. This is admitted. Not silver. 21 he says it is only the 40. That is it. Yeah, additional.
माझ्याकडे का द्याल GC case, the cross examination. Only cross-examination. And then, cross-examination only. PC money. Only translation.
Somebody else.
Only our portion. Import and works upon
Lord, his signatures are found. Checks are there. It is at page number 27. The same signature is found. Page number 29. Another signature, another check, same signature is found.
No, but signature forged is what you are saying. Nothing stated anywhere that the signatures are forged.
Manad, in the cross-examination on the CC case, Manad, we have suggested, because that is the only place we are contesting, Manad. We have been suggesting and we have brought out answers also. We can file the Kannada version with the English version also. The cross-examination of the complainant, who is the plaintiff. He has filed criminal cases under section 138 of the NI Act. There he has admitted that the signatures and the handwriting on the checks are all filled up by him, and his signature is also different.
So signature is what? Your checkbook is yours, no?
Checkbook is mine, but not it is for, he has obtained that as some security towards that 40 lakhs. He uses it for this silver medal. That is the only proof. Manad, there is a
Uses it as he is taken into security.
there is no direct relationship as far as that business is concerned. It is created, is my humble submission. As far as 40 lakhs, we are not disputing.
Apart from P1, what else is there?
Apart from P1, Millard, the notice has been issued. The notice he has received it, and then thereafter, 12A mediation, pre-mediation notice has been served.
No. Prove that you're given 120 kgs of silver.
It is his letter, Millard. Exhibit P1 is his letter.
That's
He
right.
himself says that I have given 120.
Apart from that, there is anything
No,
else?
I don't have any other letter.
No document.
No other document, Millard. This is the exhibit P1 is the, it is their own letter.
There is no GST, there is no transfer, there is no making design, nothing. No foolproof evidence. The learned judge simply accepts whatever is given by the plaintiff. Within a couple of days, decree is passed. All I am requesting is an opportunity to place all material and conduct. Even a week's time would be sufficient for me.
Let's see your limitation. Application for limitation. Admission. The limitation.
Only day.
You see your application for limitation for condonation of delay. You have said you admitted the receipt of summons.
Right, I'm under the impression that these signatures were obtained and there is absolutely no proof when I compare it.
One question would be whether you received it or not, your signatures are forged or not, that's a separate issue. Here you say it served on you.
It's a category, it's not a categorical statement.
It's a
that,
categorical affirmed by an affidavit that it is served on you.
Please.
The issuance of RAPD was served upon us. After you've sworn an affidavit in this court to say that you've received summons, you now want to argue your summons are not received and it's
We
forged.
compared the signatures.
No, not a question of comparison. You said I've not got it by email, I've got it by RAPD.
RAPD.
That's right. So you got it. What is it? What are the dates?
Dates, my lord. The 3/3/2020
Suit is the decree, the judgment decree is
judgment decree is dated 35/2024.
30.
My lord, the lordship,
24.
para 3 is, my lord, is what your lordship referred in the affidavit. It's wrong drafting by way of, because lack of English knowledge and drafting. What else? They have not admitted, that's the fact.
All right. Leave it at that.
May I read, my lord?
No, please leave it at that.
Because I find there is no, but the issuance of RPD was served upon us, place it our presence ex parte. That's what it's, whatever is mentioned in the judgment, it is mentioned. ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತ.
35/2024 is the date of the judgment and decree. Execution was filed on 13/9/2024.
30.
35/2024. 35/2024.
That's the judgment.
13/9/2024 execution is filed after 4 months.
All right.
30/11/2024 they filed the application under Order 9 Rule 13. The application was heard and it was dismissed by the trial court on 5/4/2025. Thereafter, they filed the miscellaneous appeal before commercial miscellaneous appeal number 88 of 2024 before this honorable court on 30th June 2024.
No, can't be. It will be 30th June 2025.
25, my lord, sorry. On 11/8/2025, this honorable court has been pleased to dismiss the appeal. It is thereafter the present. ಅದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದು. The present appeal is filed on 30th August 2025.
Then this is over on 11th August 2025.
11th August.
Their appeal is dismissed.
Yes. 11th August 2025, the appeal is commercial appeal AP
Dismissed.
391 of 2025 has been dismissed.
Then they file this on which date?
This was filed on 30th August 2025.
Did you furnish your affidavit by evidence?
Yes, my lord.
Where is that?
Evidence. My lord, it is at page number 14. In the paper book itself, they have produced it. Pre-mediation notice have survived. Pre-mediation notice. Prior to the filing of the suit, pre-mediation notice has been sent to him. It was served. That report you will also put get it page number 97. Pre-mediation report.
Any payment, payment of interest?
Payment of interest, they have paid it for 1 year.
How?
They have directly remitted to my accounts.
Where is that?
That document, they are not disputing it. I have not produced the document for that. There is no dispute
Before
about it.
this, before the commercial court, did you produce the evidence that you have received
I have not-
interest
I
of
have not-
66,000?
I have not. I have stated that they have given me the interest at the rate of 66,000 for a period of 1 year. That is in the print also. I have stated so.
Is it reflected in your bank statement here?
I don't have the bank statement in the,
Not in the paper book.
not in the paper book. Para number 3 of the judgment of the trial court, it is mentioned the plaintiff further submitted that the defendants have paid interest of rupees 66,000 per month till 29/5/2021, and thereafter they have stopped paying the interest
That is
and
your
also did
affidavit.
not return 120 kgs.
That is your affidavit.
That is my affidavit. That is my plain government also. Even in the pre-mediation petition also, I have stated so. They have served with the notice. Your lordship would get it. Page number 97 is the report, pre-mediation report, my lord. It is dated 13/2/2024.
Which page is it? 27. 27 is it?
97, my lord. I don't know. There are 2 pages, 2 numbers. 197 and 45. 97. This is 97 one. No. Report says that as per rule 3.4 and 3.4 on perusal of track report, notice served on the opponents 1 to 3. Opponents are called out absent and the petition is closed. Application was filed on 10/1/2024. Scheduled date was 12/2/2024. Next day, the case was closed. Pre-mediation case was closed.
Parties' names are different. Application
And others, it's shown as and others.
How have you calculated 1 lakh? Your suit is for 1 lakh, 1
1
crore.
crore 20 lakhs
How do
being
you-
the value of 120 kgs of silver millet as on the date of filing of the suit.
What is the evidence of that?
What is it?
20 lakhs.
Millet, 120 kgs of silver. That is page number 19. 1 crore 12 lakh 50,000 is what has been claimed. Out of that, 90 lakh 72,000 is the value of the silver as on the date of filing of the suit. Then the interest what he has paid from 1/6/2021 till 2 lakhs 60. Interest paid is also acknowledged here.
You've got 18% from the date of the suit.
From the date of the suit, Miller.
Do you have your 138 complaint with you?
138 copies of the proceeding. I have produced the complaint copies only. I have produced. Your Lordship would get it at page number 20. It starts at page number 29. Order sheet complaint. Your Lordship would get it page number 49. Vote ಮಾಡಿರೋದು ಅದೇ 49.
Now session it shows down limitation. Not technically. As well as in the 150. Limitation.
Suit the same 138. It's a fee.
Where is 138 reached now?
It is no argument is over. Melody, it is posted for judgment. Orders on 5th. In fact, in the said 138 proceedings, The very same exhibit P1 has been confronted to my witness by the respondent himself.
Yes.
Exhibit P1 here, what has been produced, he himself has confronted to my witness and got it marked as exhibit D2, D3.
All right. You don't even have any ground for delay here also. You are now, in fact, and filing of the first appeal as a statutory right cannot be curbed on the ground of delay.
Please. My one humble request is
We find no grounds to confirm.
keeping open the fact that the contest on merits, because let me at least protect my properties as far as properties are concerned, unconcerned with the transaction. Only the mortgage is in force. He still had time to recover the money from the mortgage. Yet that also is decreed without following proper procedures for foreclosure. There's no notice of foreclosure, nothing.
That's, there is, foreclosure is not before us. We only have money decree.
I have not sought for foreclosure. It was not a suit for.
Not a suit for mortgage.
No, it is not based on mortgage.
Then Malad,
For the above, just take down, we find no grounds. We are unable to, in absent any explanation, credible explanation for condoning the delay, we are unable to succeed to the said request. The application is accordingly dismissed. The appeal is dismissed as well. Consequently, the appeal is dismissed as well. The rest will dictate it all. The rest of the thing will dictate.
25, 26 are urgent. Still number 27.
Okay.
The appellate appear for the appellate matter. Dismissing the writ petition that confirming the order of the and district judge. Where that it is in a section 16 pre-petition file. That after 10 years that it is where that line was drawn in the year 1996. That compensation that according to pay that not the and trial court not observing that no material which has been produced. And even that it is in a first time that the 2006 the notice was issued after 10 years claiming compensation.
What about your delay?
That my defense blood that we have paid compensation.
No, your delay.
The delay my our part, not that we are approval, all those things, not that we are securing the information change, not that we pay the name. The long blood that is the 96 blood that which has compensation is paid. That securing information where that it not that it is concerned.
Lord, I have also filed my objections to the application filed under Section 5 of the Limitation Act, my Lord. There is delay of 273 days in filing the present appeal, my Lord.
Let's see your main ground. Main ground is limitation.
Lord, electric lines were laid in my land way back in the year 1996, my Lord. I was not paid any compensation. In the year 2006, my Lord, I filed application under Section 16 to the district court seeking for compensation for the mango trees that were cut down in my farmland for laying of these lines, my Lord. Trial was conducted, and the contention before the learned district judge was that, my Lord, compensation was paid in the year 1996, my Lord. No compensation was paid, and in spite of giving several opportunities, both before the district court as well as before the learned single judge, my Lord, not even a scrap of paper they have been able to produce before the court to demonstrate that 2 lakh was paid as compensation in the year 1996. Hence, my application that was filed in the year 2006, my Lord, was considered and compensation was awarded, and which is already paid, and I have also received that, my Lord.
Compensation paid.
Lord,
When was it paid?
in the year, only upon me making application before the district court, my Lord, 3 lakh compensation was fixed. 3 lakh and odd compensation was fixed. And also, and my instruction is that, my Lord, my client has also received that compensation, my Lord. Subsequently, challenging that order, my Lord, they have come up before this honorable court, and single bench has confirmed the order passed by the learned district court, my Lord. Challenging that order, my Lord, they are before this honorable court, saying that it is barred by limitation, my Lord.
No. The learned single judge holds that there is no limitation because compensation was not paid.
Was not paid, my Lord.
So when was it paid?
Only upon the order passed by the district judge, my Lord, after the order passed by the learned district judge, my Lord. In miscellaneous petition number 114 of 2006, my Lord.
But that was challenged before the learned single judge.
That line was done 1996. That first time, Lord, that in the year 2006, Lord, that notice was started.
So when did you pay the compensation?
The compensation during that time has been paid 2 lakhs, Lord, that.
Where is that?
That, Lord, that material on account of after lapse, Lord, that we are not, Lord, that place is concerned.
When did you deposit the compensation? If
The
you've not
compensation directly paid to the party, Lord, that we are not
When?
deposited before.
paid, when?
That is in the 96 itself, Lord.
No, that's not what he's saying.
That
It's
he
all
is
about
now
this-
not that taking advantage that we know material we have placed. That is the denying so far as that is concerned.
Where have you said that you paid in 96?
That I have stated in that appeal memo.
When?
96 it has been paid 2,02,009 rupees to her damages. That is the why that delay in securing information that how much payment made because of the agent was made that it is during such time.
And then it single judge holds
That
that you have not paid.
the lack of the material that it has been that where that not paid. Even otherwise, that I may myself.
So don't say, well, let's have a fact state. The learned single judge has said that you have not paid and therefore your limitation will not run. You cannot fault the learned district judge for taking up the compensation claim. Couldn't be barred by limitation because you've not paid. You say you've paid.
Yes, yes.
We are asking you which is the date. Obviously, that flows from the order of the learned single judge.
That single
If you
judge-
think the learned single judge is incorrect, then you should point out.
that is not that I sought for the bank statement to the transferring fees that cash will not pay, the bank transfer.
Whatever
Old bank that I securing that bank statement. That is not that it is in a delayed so far as that is why that price I took.
At
time
least you
so
can
far as
say
that
you
is
can
concerned.
say which. Don't
But
have to get-
that definitely I'll place it under that
Where?
kind of one
Now
opportunity.
You can't. There are 273 days. You not challenge that at all.
That if the compensation would pay, not paid, that 96 that till 2006 that it is that after the 10 years that come with saying that compensation.
You not paid 10 years, no? Had you paid, the matter would have got over.
In spite of giving opportunity before the trial court, before the learned single judge, the trial court has awarded compensation only at the rate of 400 rupees per mango tree, my lord. Which is very feasible.
Mistake. The appellant has filed the present. Appellant bracket here after KTP. CL. The appellants have filed the present appeal impugning an order dated 6 June 2024 passed by the learned single judge in writ petition number 10651 of 2017 bracket J at AEB. The appellants had preferred the said petition, assailing an order dated 31/2016 passed by the learned district and sessions judge Tumkuru in miscellaneous petition number 114 of 2006. Good stuff. The said petition was filed by the respondent claiming was filed by the filed by the respondent claiming compensation for an amount of rupees 8,20,000 on account of the damage suffered as damages suffered for removal of mango trees, 80 mango trees. By the appellants bracket KPTCL for laying the lines on the lands belonging to the respondent. Full stop. The appellants had contested the said claim. They claimed that the respondent's claim was based on the assertion that each mango tree was yielding rupees 500. This was contested by the appellants. However, during the course of the proceedings, the appellants also raised the issue of limitation. Full stop. They claimed that the electric lines were drawn in the year 1996. However, the respondent had filed the petition under section
16, Lord.
19 of the Indian Electricity Act 1910, read with section 10 and 16 of the Telegraph Act 1985 in the year 1996, in the year 2006. Good stuff. Although no such ground was raised in the statement of objections filed in the written statement of objections filed by the appellant, the said contention was advanced at the time of hearing. Full stop. Next paragraph. The Lieutenant District Judge did not accept before that, it was the respondent's contention. The respondent contested the challenge on the ground of limitation. This is the respondent's case that he had never received a notice intimating the compensation fixed for the loss caused. After and he continued to await the same. However, in the year 2006, the owners of neighboring land, compensation was disbursed to the owners of the neighboring land, and therefore he issued a legal notice to the appellants demanding the same. Although the appellants received this notice, they did not respond to the same. Therefore, the respondent was constrained. And therefore, the respondent had approached the learning, had filed the petition. Next paragraph. Parties had led the evidence, and the learned district judge found that district court found that the appellants had been unable to refute the respondent's claim that he had not received any notice or compensation. Full stop. Although the appellants claimed that they had paid compensation, and had paid the compensation to the respondent, there is no evidence to establish the same. We may note that even in these proceedings, no documents have been produced to establish that any payment, that the compensation had been paid. We may note that neither before the learned single judge nor in the present appeal we may note that the appellants have not produced any evidence to show that the compensation had been paid either before the learned single judge or in the present appeal. Let's start. It is not disputed that 400 kV electrical lines had been raised over the land of the petitioner, over the land of the respondent, and he was entitled to compensation. Full stop. In view of the above, the learned judge had rejected the intention that the respondent's claim petition was barred by limitation. Next paragraph. The appellants appealed the said decision before the filed a writ petition, being WP 10651, challenging the said decision. However, the learned single judge found that there was no evidence that the appellants paid compensation to the respondent, and therefore the limitation for seeking and issued a notice of compensation or paid compensation to the respondent, and therefore the period of limitation, and therefore its claim would not be barred by limitation. Full stop. The learned single judge also noted that in terms of under section 10(d) of the Telegraph Act, the appellants were obliged to pay compensation for the damage suffered. Let's start. Next paragraph. The appellants have, the learned counsel of the appellants submitted the present that the petition filed by the respondent was barred by limitation on the same grounds as were canvassed before the district judge as well as before the learned single judge. However, the appellants have not produced any document to evidence either payment of compensation, either issuance of notice of that the notice of compensation was received by the respondent, nor have they produced any documents in support of their claim that the compensation had been paid. Full stop. Was paid. Next paragraph. We may also note that the present appeal is filed after an inordinate delay of
273 days.
273 days. The application seeking condonation of delay does not set out any credible reasons for the said delay. It merely states this is sufficient explanation for that. Don't say credible reason. Sufficient explanation for the said delay. Full stop. merely states that the writ petition was disposed of on 6/2024. And the advocate had applied for a certified copy of the same. Applied for the certified copy of the same and forwarded it to the corporate office on 25/11/2024. Full stop. An approval was obtained for filing the writ appeal on 5/12/2024. Thereafter, the advocate sought for certain information with regard to the compensation paid to the respondent at the time of drawing of the electricity lines over his land. And after securing the said record and the information that a sum of rupees 2,02,009 had been paid, the present appeal was prepared. However, as stated above, together. Next, the affidavit is, the application is bereft of any details as to any specific dates, is bereft of the relevant details as to the specific dates, as to when was the certified copy of the order applied for. So when was when did the advocate seek further information and when was it supplied? Full stop. The explanation provided appears to be, it doesn't appear to be credible, considering that the appellant has not provided any information, has also not provided any material in support of its contention that the compensation had been paid to the respondent at the time of drawing of the lines as contended. In view of the above, the present appeal is dismissed both on the ground of, in view of the above, there are no grounds to condone that, to allow the application for condonation of delay. In view of the above, the appeal is dismissed both on the ground of delay as well as on merits.
Excellent.
This is mentioned matters. List 1, serial number 40.
Copy of a petition. In this matter, minutes,
I'm appearing to the connected matter.
Yes.
I'm appearing the connected matter, my lords. There is Mr. Ravi
Item
Shankar
40 is the one.
40.1, my
Yes,
lords.
Who's appearing in 40?
40, I apply for 40 minutes. This the
Yes.
matter is disposed of minute. And this honorable court noticed minute that the part by refusing the interim order, the construction was completed, and therefore minute via media was suggested that every transaction that takes place minute in that area, 2% additional stamp duty to be paid. That's how the matter was going on. Particularly through an IM minute, the government sought permission to develop a particular area minute through the money that was that's realized. the matter ends so far as I am concerned. Then Mr. Ravi Shankar's party, my lord, they had complained that it is their part of land that is now being used, my lord. That's how the application is filed in my case. I leave it to the court so far as I am concerned.
Who's pressing that application?
Earlier, my lord, I had filed the application in the 1996 matter, my lords. That is 40, my lords.
Yes.
Subsequently, I filed a separate petition, my lords. That is 40.1.
Yes.
On the ground, my lords, I was not party to the writ petition.
Yes.
An order came to be passed, my lords, without making me a party. And an order is passed, my lords, on 25/3/24, which I have impugned, my lords, in the subsequent petition. That is 13256, my lords. I've impugned the order, my lords. Earlier, I filed the IA, my lords, in the earlier matter.
Yes.
At Annexure A, my lords, page 26 is the order passed by this honorable court.
Yes.
This order, my lords, wherein, my lords, my land is given for the purpose of building a public healthcare center without, my lords, giving me an opportunity of hearing. The Deputy Commissioner, my lords, after the order of the honorable court, transfers the land, my lords, from me to building a public health center, my lords, without giving me an opportunity of hearing, my lords. Therefore, my lords, I challenge this order before, my lords, the Karnataka Appellate Tribunal, my lords. The Appellate Tribunal, my lords, rejected my application on the ground that this honorable court, my lords, in the impugned order, had directed construction of the public healthcare center. Therefore, my lords, my appeal against the order of the Deputy Commissioner came to be rejected, my lords. Then I filed a writ petition, my lords, before the single judge. Your Lordship will see the order, my lords, at page number 146, my lords, is the order. I had challenged the order of the Deputy Commissioner, my lords, before the single judge. Your Lordship will see 152/11 page, my lords. Para 7.
Yes.
On a careful and plain reading of the directives issued by the division bench in WP so-and-so, this court is of the considered view that the interim order granted earlier in favor of the petitioner requires to be vacated. The division bench issued a categorical direction to the state to commence the proposed construction of a primary healthcare center in survey number 21, measuring 6 guntas. Furthermore, the division bench
Yes.
Furthermore, the division bench 152 minutes. Furthermore, the division bench has emphasized the urgency of the project by explicitly stating that the construction needs to be accomplished on a war footing. In view of such clear directive, this court finds no justifiable reason to continue the interim order. That was my submission. The interim order passed by this honorable court on 25/3/24, which challenge, my lord, was passed without giving me an opportunity of hearing, my lords. I've been, my lords, told I cannot challenge the order and my interim order got vacated, my lords, on the sole ground that this honorable court in the impugned order, my lords, has passed an order directing that the primary health care center, my lords, be built in my property.
Yes. You have not appealed that order.
My lords,
You have not filed an appeal against that order.
immediately, my lords, I filed the writ petition, my lords.
You filed a separate writ petition.
Please.
Question is, how will you maintain a writ petition against an order of a learned single judge?
No,
Pass
my lords,
in a
I
writ
have,
petition.
my lords, your lordship will see my petition, my lords, para number 19. I have not challenged the order of the single judge, my lords. I have challenged the order of this honorable court, my lords. I have sought for review of the order of this honorable court.
You're challenging the order of 25/3,
Please,
2000.
my lords. At page number 25, along with the petition, 26, my lords, along with the petition of this honorable court, my lords.
Yes.
My lord, I'll take notice, my lord, and I'll seek instructions. My lord, may I see respondent number 8?
Yes.
My lord, he is dead.
My lord, serial number, the respondent number 8 to 11, my lords, were the parties in the first matter, the 1996 matter. Therefore, my lords, I had to make them a party, my lords.
You can delete them, a person
please,
is
my lords.
expired. 8 is expired.
Please, my lords. In fact, my lords, your lordship will see, my lords, the earlier petition is disposed, my lords. My cause only is against the state government. The private parties are no more involved in the matter. My grouse, my lords, only against respondent number 2 to 7, my lords.
So why have you made them the
Because they are parties to the earlier petition, my lords. It's a review petition, my lords. I had to make all of them parties, my lords.
It's not a review petition. You filed a fresh writ petition.
Review, my lords. Your lordship will see the prayer, my lords, in my petition.
Then we'll examine your application for review in that. Why do we require a separate writ petition?
Because I was not a party. The Supreme Court, my lord, says if you're not party to a order, you can file a fresh petition, my lord. Hence, I had filed the petition. That's one reason.
May I just clarify that position, Miller?
Yes.
Miller, in the order dated 13/4/1999, passed in 31/8/15 of 96, this honorable court has made the question clear, Miller. The writ petition is kept pending only for the purpose of monitoring of deposit of 2% of amount and to appoint an independent body as stated supra for the purpose of framing of scheme and utilization of the amount. In all other aspects, the petition is deemed to have...
Your PIL is on use of funds.
Your lordship, sir.
No,
No. Writ petition was filed. PIL was filed for in respect of a property developed by Sinister Mr. Dharmendra. Then interim order was not granted. By then, by the time the writ petition came up for final hearing, the building had come up, Then this honorable court felt, that instead of directing demolition of the buildings, this is what the court said. The subject matter of this petition was for the sale of agricultural land for the purpose of setting up residential apartments in the South City. By the time final order came to be passed, it was observed that structures had already been completed. That is 13/4/99 order may be seen,
You have to take instruction. The PIL was something else.
Yes, that's true. Your lordship is right. Therefore, so far as that writ petition is concerned, that is closed. But the property that was developed there, this honorable court is a novel method, they found out.
This property is not a subject matter of the writ petition.
No.
That's all that he's saying.
This is not.
You can't build on somebody else's property.
Lord, I don't know what the stage is and what the current situation is.
You've come back and said, we've got a property, please allow us to use the funds to build that. Court said, all right, instead of getting something else, we build there. Now he's filed and saying it's my property. That you said, the division bench just said field there, so you feel that.
Their case, my lords, before single judge, their case, my lords, it
What
used
was
to be,
the order before the judge?
my lords,
What was the order? You had an interim order.
I had an interim order, my lords, to stay of the deputy commissioner's order, my lords.
No, what was the interim order in your case?
Before the single judge, my lords,
Petition.
there was a stay of the deputy commissioner's order, my lords.
Lord,
Not
I
to
don't know what the current
assign the land for
situation is.
development, my lords. Now the problem is they've already built 3 floors of the project, my lords. I'm only requesting the status quo as on date.
Tell us what.
My lords, my only request is they built 3 structures. They're going to start a primary healthcare center. My lords, then it will be
If they build the structure, how does it? How
status quo as on today at least.
Give you.
Or a short date, my lords.
Yes, sir. Give you a short date.
Please.
There's a notice in 40.1 and also in the application filed in 40. So,
16th and 17th may be avoided, means.
6th of April.
Great.
Obliged.
Please.
it's a notice to all other respondents other than respondent number 8 in 40.
Number 49.
And that's a shorter date. I'm sorry.
Yes.
For pressing much shorter date because they're building.
April review.
Like this month, my lords.
April is fine.
Please.
Number 49.
Appear for the complainant in the matter, my lord. My lord, this contempt case stems from an order dated 20th February 2025, where the respondents were directed to hand over possession to me in respect of a property in which there were 2 connected petitions before the learned single judge, and claim of encroachment was ruled in my favor. And if your lordships may turn to page number 18 of the main petition, my lord.
Yes.
Which matter? 49, I'm not there. No,
We'll list it tomorrow. We'll wait for it. Tomorrow.
I'm busy with my work.
Let's put both of them tomorrow. One more.
This goes still number 26.
Respondent.
Yes.
May
Half an hour.
Is, my lords, I'm between the rock and a hard place where, my lords, they don't permit me to execute the work where, my lords, I have only given a program that I will finish. The majority component, the financial component of the work, my lords, where I was supposed to get, my lords, closure of the road is not given to me. Please.
You can't do the work for the road that's closed, but where the road is open, what prevented you?
My lords, that is what I'm saying, my lords. For the road which was open, that is the flexible pavement. My lords, what prevented was even before, my lords, my agreement was finalized, NHA, my lords, floated a proposal for, my lords, widening the very same work, the very same stretch. 80% of the land, my lords, in October 2016, the very chief engineer, my lords, has an inspection. He records that 80% of the land, of the 90% which was supposed to be given to me, my lords, is with NHAI because they are planning, my lords, additional an expansion of the very same road. So, my lords, the entire, my lords, the argument was on the basis of an oral instruction that, my lords, I had stopped the work is what the appellate tribunal concludes that I was prevented because the instructions were oral by the department that don't do flexible pavement. There, my lords, the argument was I did not enter the witness box. My lords, may kindly see the documents. I'll take, my lords, the documents now. My lords, what has happened is November 2015 is when, my lords, my agreement is entered into.
So
My lord, please.
Somebody tell you don't do the work.
Please.
First thing you do is to write a letter to him. Maybe stop the work. Get
My
a
lords,
confirmation.
my lords, it has happened, my lords. In fact, there have been communications. My lords, may kindly take my compilation. My lords, I'll just take, my lords, through those.
Communication, contemporaneous communication, acknowledging that they have been.
My lords, their own documents prove it. My lords, may kindly, my lords, come to the compilation. My lords, may come to page number 12 for a moment, please. My lords, it starts from page number 10.
Yes.
My lords, this is the NHA's, my lords, request for proposal. My lords, may kindly come to page 12, the last table.
Yes.
My lords, as I said, my lords, my agreement is in November 2015, 6th of November 2015. My lords, this RFP is by NHA on 24th of September 2015. My lords, may kindly see, my lords, what is proposed, my lords, may now kindly come back to page number 10. The length, my lords, of what is proposed here. My lords, package number 1, 4-laning of Hassan, existing kilometer 189, design chain so and so to Maranhalli 237. My lords, the kilometers are 189, my lords, to 237. Now, my lords, may kindly see the chart I gave, my lords, on what, my lords, is overlapping. My lords, 216 to 237 for me, my lords, is a flexible pavement. That is the road which, my lords, the appellant has argued that was open, where I could have done the work. My lords, this, my lords, was a tribunal constituted, my lords, of domain experts. All the three, my lords, retired chief engineers, my lords, from the department. Let's kindly look at the background. Let's. NHA has called for the work. Now, my lords, the next document, in fact, my lords, the NHA writes to the department saying you also called for the very same work. It is going to be an infructuous expense. Please take a decision. My lords, may kindly come to the next page. Lords, page number 15, if my lords may have. That is, my lords, is the NHA's, my lords, it was exhibit C34 before the tribunal, my lords, the first column. What, my lords, the RFP, my lords, just looked at. The work order was given in March 2017, my lords, for the very same work. This is, my lords.
15 is status as on 31st March.
Please, my lords.
Yes.
My lords, the first entry there
Yes.
is, my lords, the same work which my lords just read, the RFP, my lords. For, my lords, 4 laning off from Maranalli, my lords, the entire stretch, which, my lords, collides with the flexible pavement stretch. March 2016, my lords, the work order has been issued. My lords, it's slightly illegible, my lords. I'll let's furnish a typed copy as well.
Okay. Where is the work order for this?
My lords, the my lords, award date, my lords, we find it column number 5, my lords. March 2016, my lords, is the award. My lords, the work order was not given to us. This, my lords, was also procured under RTI. March 2016, my lords, the contract was awarded. This is 5 months after, my lords, my agreement comes to be executed.
What is the date here, which is now not legible?
My lords, March 2016. The date, my lords, in March is not mentioned there. Only the month is mentioned, my lords. March of 2016.
What is the start date?
My lords, the start date is March 2017. Date of completion, my lords, is March 2019. My lords.
Yes.
Now, my lords, we come to page number 28. My lords, only for this issue, my lords, the pages are slightly, my lords, arranged. My lords, we come to page number 28.
Yes.
My lords, the NHA, my lords, writes to, my lords, the principal secretary, my lords, the public works department. This is, my lords, August 2014, even before my contract is entered into. My lords, during the meeting held on so-and-so, initiative taken by NHAI for improvement, NH State Wing PWD for improvement of following works in Shiradi Ghat was discussed. My lords, strengthening from providing rigid pavement, and my lords, providing both my work as well as another work. Then, my lords, the next page. It is pertinent to mention that NHA has already proposed for improvement of Shiradi Ghat section with 4-lane configuration, duly undertaking geometric improvements, both horizontal and vertical, along with improvement of curves and hairpin bends. It is understood that NH wing of the state PWD is undertaking the improvement work from 216 to 263 on the existing alignment, whereas NHA is upgrading the subject project with geometric improvements. The expenditure made by Ministry, National Highway Wing, State PWD on existing alignment may be infructuous. It is requested that NH wing of the PWD GOK may take up improvement work correlating with the NHA proposed alignment, such that maximum portion of the improvement now can be utilized by NHA while upgradation.
So where does it say stop work?
My lords, it doesn't say stop work. My lords, the argument was that, my lords, the arbitral tribunal came to a conclusion that, my lords, I was instructed to not do the work there, my lords, oral instructions.
In fact, on the contrary, it says the maximum portion of the work of the improvement now done can be utilized by NHA.
Please, my lords, may kindly come to the subsequent developments as well. Yes. My lords, may come to now, my lords. My lords, page number 21.
Yes.
My lords, the department, my lords, they themselves, my lords, they are discussing that, my lords, there is an overlap. My lords, may kindly come to page 21. My lords, this is January 2016. My lords, about 2 months after my agreement. My lords, ministry in the letter dated so-and-so has accorded administrative approval. My lords, may come to the third paragraph. My lords, in the meanwhile, the project director NHAI Bangalore in the letter dated so and so addressed to the chief engineer National Highways Bangalore has informed the status of the upgradation widening work of Hassan to BC section in the respect of package 1 and 2. And package 2 covers part of the work of strengthening from kilometer so and so 216 to 237 and providing rigid pavement from Kempahole to Adahole Shiradigat under EPC mode. NHAI package for laning of Hassan Bantwal section, chainage so and so to so and so. NHAI package number 2. It is informed that for the above package, the bidding process has been initiated and the last date of bidding is 22/12/2015 and the process of approval of 3G for which award is in progress and is expected that 90% possession of the land would be available by 31/3/2016 and the proposal for diversion of the forest land for an extent of 33 hectares has been forwarded for MOF duly recommended by GOK, which requires clearance from MOF and it is expected to take longer period. And under package 1, a bypass to Sakleshpur town has been proposed from existing 219 to 226. Since rigid pavement is proposed, the strengthening work from existing 216 to 219 and from existing 225 to 237 on either side of the Sakleshpur bypass would not be utilized by NHAI. Also, NHAI has designed the alignment by improving horizontal and vertical geometry, hence it will not be possible to utilize the existing surface. Minutes the para after. Minutes here again minutes. Kindly see minutes what is left. What is left minutes is the Sakleshpur bypass. Which minutes I was told to work, I have completed the work. It is an admitted position. 6.06 kilometers minutes, there is no dispute vis-a-vis the quality or the quantity of the work. It is the bypass. Which minutes is excluded from the NHAI's acquisition. Sorry, the NHAI's proposed development. Minutes the para after the para minutes is straight. In the meanwhile, the ministry in the letter dated so and so, dated 17/11/15, has noted that the ministry during the year 2014-15 has sanctioned the above work and the state government has invited tenders. And it has also learned that the NHAI has invited bids for 4-laning of NH48 from kilometer 236 to 328, which covers part of 4-laning of Hassan Bantwal section of NH48 from kilometer 263 to 328, design change so and so, and has requested to furnish views and comments on further continuing with the above mentioned PR work, so as to avoid any infructuous expenditure and to expedite comments at the earliest. Minutes may kindly put together minutes the conduct minutes of the respondent and minutes what their own communication says. Minutes I as a contractor minutes I have minutes mobilized my men and machinery minutes, that is I have received the mobilization fund as well. Minutes they tell me that we will permit you to execute both rigid and flexible payment. First they say minutes we will close the road, then minutes that does not happen. Then minutes they say, okay, wait for some time. We will ensure that the work happens. Minutes I wait because minutes my investment is stuck there.
No, there is communication from you seeking that you told me to stop.
Minutes there is no communication which says that minutes you have orally minutes told me not to commence the work on flexible payment.
Can't rely inference of one letter written by NHAI to another.
Minutes not only this. Minutes may kindly now come to minutes the minutes
that you've been told to stop work.
Minutes may kindly come to the minutes of meetings minutes of the very same chief engineer. Minutes may come to page number 30.
Yes, 30 years.
Well, this is October 2016.
Yes.
That's about 11 months from minutes my agreement.
Yes.
Minutes may come to minutes paragraph number 3.
Yes.
Inspected minutes on the day of inspection so and so. It is reported by the Assistant Executive Engineer, National Highway Subdivision Sakleshpur, that from NHAI sources it has come to know that about 80% of the land is in their possession, as against 90% required to hand over the site to EPC contractor, and decision is required in respect of going ahead with the executing sanction work or not. Minutes may kindly now turn the page over to see minutes what decision they take. Minutes in October 2016. Minutes what they say in the next page. Minutes may kindly, I'll just read the next paragraph. It's more continuous. In this respect, considering minutes may come to page 30. I'm so sorry, minutes. Last para. In this respect, considering the bad condition of the road and inconvenience caused to the public, the following instructions has been issued. From 219 to 225, totaling 6.06 kilometers, where the NHAI authorities are not going to take up any improvement works. The sanctioned item of work, that is semi-layer, patching of the potholes, DBM 50 and BC 40. Whereas DBM is dense minutes bitumen and BC minutes is the tar that is laid on top of that.
Dense bituminous macadam.
Macadam, yes. 40 mm shall be carried out without any deviations. For the balance reaches from 216 to 219, that is the flexible pavement, and 225 to 237, that is the rigid pavement. totaling 19.34 kilometers. The periodic renewals with the required provisions may be carried out so as to avoid inconvenience to the road users till the time of grounding of NHI four-laning project by EPC contractor by completing the process of taking into the possession of 90% of the land, handing over the site to the contractor, mobilization of men and machinery, etc. by the EPC contractor. It is instructed to submit the change of scope proposal as per the provisions of EPC to the effect mentioned below. As they reduce the scope, that is direction is issued to reduce the scope. Then, my lords, for renewal and for maintenance. My lords, if it is the the case of the respondent that the appellant that the entire road was available for executing the work, why would the very same authority, as the chief engineer in his own inspection, say that the 90% of the road which is supposed to be handed over to me is not available because the NHI
80% of the land.
Yes.
That may be the acquisition of the both sides of the land.
No, minutes. Kindly see, he says 80% minutes of the handover of the site. Kindly come to page number 30 minutes. He says, from the NHA sources, it has come to know that about 80% of the land is in their possession as against 90% required to hand over the site to EPC contractor.
That's right.
Correct.
That EPC contractor is getting which site?
Minutes, the very same site, minutes, where this work is also, minutes, there is a conflict.
EPC contractors refers to you or the contractor?
Minutes, here, minutes, it refers to the contractor who is getting NHA work.
Here it is. Therefore, the land here would refer to the acquisition
of the land. But minutes,
that is not what is available. That can be handed to him.
Minutes, then kindly see minutes what they do next. Minutes.
Now you look at your review of progress.
Please.
Right below.
Yes, the progress of the work has been reviewed with respect to the assurance given by the contractor during the meeting held on 13/10/2016. But in all the cases, the contractor failed to achieve the target as assured. Further, it is decided to give last and final chance to the contractor to make use of the working period from October 16 to April 2017 of the region, even though 18 months is the stipulated working period as per the agreement, and to give progress as mentioned below.
18 months here, no?
Yes, but
you're a party to this.
I was a party. Yes, I was a party to this. Now let's kindly see what they have descoped. Well, it's the portion where there is an overlapping, they say don't do any work. They say I'll only let you do periodic maintenance. The portion where there is rigid payment where the road had to be closed. There they say instead of the 40 mm DBM, they reduce it to 30 mm. What has happened is there is an overlap. They were aware that there was an overlap. They did not want for it to become an issue at any point in time. I mean, that's what I'm saying. Perhaps the overlap they didn't want for it to become an. It's probably a publicity issue, the public issue. Therefore, what has happened is, I have mobilized. I was supposed to execute the first flexible payment. My contract admittedly says that I will execute the flexible payment first. I will do flexible payment, then I'll tackle the CDs, that is the culverts. Thereafter, I'll do the rigid payment. There is an overlap. The very same authority says I'm going to descope your work with respect to the portions where there is an overlap. Whereas that is why the arbitral tribunal comes to a conclusion that the overlapping is proved. Even though, there is, to answer my lord's question, even though there is no document which contemporaneously written at that point in time saying, you've poorly told me not to do the work. It stands proved by virtue of what has happened thereafter. This is not my document. This is an inspection by the very same chief engineer. May kindly now see how they descope the work also. October 2016. Please. Great.
Yes.